All right, cool, great. Still, we're going to have a bunch of people trickling in. We appreciate those of you who come, and it's for sure a blessing to you guys as you guys navigate the real estate industry and especially land development. We try to bring in the best of the best, and both in spirit and light as well as in talent and in the science and intellect side of land development. So that's why I called on my guy here, Jeff. I've worked with him a bunch, huge talent. I'll introduce him shortly, and he'll be your speaker and everything. Also, here I have our broker and CEO for McCleary Real Estate. So you can come and talk to Amy Clark about any questions you have, as well as we have Leland here who you can ask questions. But hopefully you have more questions for Jeff and less questions for us. It's his day really today. So we do this every first Wednesday of every month. And the premise is, if you watch the series of all these master classes, you would be a master at land development. And you would have the capacity to be able to go and do and be able to be literate in the land development game. Okay? That's really the premise behind that. And so we're going to continue to bring in awesome people. This month was Jeff. Next month, as you can see, January 7th, if you guys click the QR code, it will send you to our next month's Masterclass. That's going to be Steve. Steve, raise your hand in the back. Steve Shields. So the cool thing about Steve is he used to work for Wadsworth back in the day, and we poached him for our acquisition side of sorts, right, Steve? And then we had some tenure together. And then one day we were sitting and I was like, dude, you have a bigger mission than just being acquisition for land development. We had a bond on that, and he went out and he's become the who of high net worth individuals and celebrities in trying to get their mind right and their mental and emotional game on lock so that they can unleash themselves in whatever career path or success they're trying to achieve. And I keep him close for a reason, right? I'm trying to unleash myself as well as I have a bond with him too. So he's going to come and present. And the whole premise that led to that was the fact that we were talking, and I was trying to, because I'm always trying to figure out how to help others be really successful. And we were talking about some of the individuals that I'm helping and mentoring. And I was like, man, I wish I could just give him some of this. And he was like, Steve, really what you're talking to is your mindset. It's your grit that's like a game changer. And he talked about how I've spent so much time in improving myself that mentally and emotionally I have more bandwidth to make my way through the challenges and navigate complexity and continue to be an optimist and a solution provider rather than just hang out too long in doubt, fear, and problem. So that's why we're bringing him. Start off the new year right. At the end, if you guys want to connect with our team, we have a bunch of different companies we fund to do land development, to whatever it is that you want to learn in land development. You can schedule a time with our team. And then also we want to hear from everyone. We've had city council to everyone get involved in this event. And we want to hear back, and get a review from you guys on what your experience is and how we can get better, or if this is something that your friends could benefit from. So please feel free to do that. With that being said, I'm going to pass this along to Jeff. Jeff, do you need me to help you put this on?
That'd be great.
Cool. So Jeff is going to jump in and introduce himself. to everyone. If you have a question, as a side note, just raise your hand and they'll, at any time they'll answer. And also, if you need to get up and leave, feel free. Like, this isn't a prison cell. This is meant to be of a service and a blessing. Don't feel awkward. If you need to use the restrooms, they're right there. If you need to leave because you have professional things that you need to get to, great. But hopefully you can stick around and ask questions from these guys. They are experts. And he can tell you about his career path and now he's an expert. So I'm going to pass it to you and Wayne.
Well, thank you very much, Steve, for that. Okay, and Mike's working fine, and
yeah, is your light straight up?
I don't know. He put it on.
already
Shouldn't he
messed it
know
up.
better? Yeah, it's straight up.
Okay, just want to make sure.
So, well, I'm Jeff Warr. This is my partner, Wade Thomas, and I'm just going to take a minute and tell you a little bit about us and our practice, and I'll tell you about my experience, and then Wade can take a minute and tell you about his experience, and I guess what even gives us any justification for standing up here in front of you today. But really, I'm just an Idaho farm kid. So I grew up on a potato farm in the Magic Valley, southern Idaho, which is the Twin Falls area, and we had a very large, potato farm. And I can remember as a kid, in fact, I still get really nostalgic during the fall, mostly during potato harvest season, when I drive back home, for something, and, it's just kind of that smell in the air and, just that feeling. But I can remember during the late 70s, and we were going through a drought, and where I grew up around the Twin Falls area, it was kind of on the north side of the canyon, the Jerome area, and water is king there, and so everything there is watered with deep wells, and I can remember a couple of different things that really made me decide that I didn't want to go into farming. One was, I remember during the middle of one of those summers in the late 1970s, the well going dry. The aquifer had been dropping, much, and all of a sudden here we are like in July with this potato crop in, and I was old enough to figure out that there was something that wasn't very good that was going on, but just watching the stress on my parents' face as they had to do that. The other thing, though, that I think I probably made even more of an impact on me was, I can remember a year, and I don't know what caused it, but my dad had really a large amount of what we would refer to as open spuds that year. Lots of times, when you raise potatoes, you're under contract with Simplot or Orida or somebody like that to buy these. But then sometimes, you take the risk and you raise potatoes and you're not under contract on them. And the market fell out that year. And I can remember that next spring going to the potato cellar with my dad, and just with a backhoe, loading up potatoes, dumping them back into the truck, and then taking them out to the desert in the adjacent to our farm and just dumping them. I mean, there was nothing that you could do with them. And I remember that being one of the few times I could just tell the look on my dad's face and the stress, and I thought, I sure as hell am not doing this for a living. I'm telling you that. So I ended up going to law school, which, I don't know, I look back and farming may have been the better choice at times. But that's kind of where I grew up. As far as my legal background, I did my undergraduate in finance at BYU, and then ended up going back to Idaho to go to law school. And I spent most of my career in Boise, but started out first in Twin Falls. And that's where I really got my taste of real estate. I can remember I served on the Planning and Zoning Commission in Twin Falls, and within a year or so, then they asked me to be the chair of the Planning and Zoning Commission. And here's this young, attorney, And it was at a time, and if any of you are familiar with Twin Falls, there's been just massive development out along the rim of the Snake River Canyon. The mall had been built there by Price, prior to my serving on the commission, but all of the development was really starting along that canyon. And I was the chair of the Planning and Zoning Commission when some of those first developments went in. And I can tell you, I can remember the first time after I had actually left Twin Falls and decided I need to get to a bigger market, and went to Boise to do the things that I really wanted to do. But driving in from the freeway, driving across the Prime Bridge there, across this beautiful canyon and this, incredible setting, and looking, and the first thing I could see was a Taco Bell sign. And I thought, oh my hell, I did that. But it gave me, I think, some interesting perspective on land use planning and some things that I wanted to do. From there, I spent part of my time and part of my career has been in private practice, but part of it has been in-house. And so I spent several years, and that's where Wade and I got to know each other, in-house with a very large real estate development firm, or real estate investment firm in Boise. And we had about 25 million square feet of retail and office in about between 30 and 35 different states. And it was a blast. I absolutely loved it until 2008 hit. And remember I said it was office and retail. And so, it was just an absolute disaster. And so what happened after that is I got the opportunity then to work on what ended up being, and probably still is, the largest bankruptcy of an Idaho-based company with billions and billions and billions of dollars worth of claims in it. And it was an interesting experience because I got to turn around and all of the transactions that I've got to do, I got to undo. And an attorney never gets to do that and realize, okay, this is what I would have done differently. If somebody's undoing your transaction, it's because something's gone wrong and somebody else is undoing the transaction. But I got that unique opportunity to spend 5 years working as the counsel for the trustee under that Delaware bankruptcy. And it was a fascinating opportunity. Left there and was a partner in a large firm in Boise, which was the preeminent real estate firm in the state of Idaho. And then about 6 years ago, was asked to come back down here, and I was the chief legal officer at Peg Companies in Provo. So again, several $1 million of assets under management. And then a couple of years ago, it was like, okay, time for a change, enough is enough. So the last couple of years, I have worked with a company called Amplio, as well as what Wade and I are doing ourselves. And I spend a lot of time acting as a court-appointed receiver for problem real estate deals all over the country. It has been a lot of fun, and it's mainly been a lot of fun because I don't have to be the lawyer on it. I get to be the receiver, and when the law stuff comes up, I can say, I have a lawyer that gets to handle all of that crap. And so that's been a lot of fun. But in doing that, and with our in-house experience, Wade and I got together a while back, and we just saw a need for smaller companies, mostly, to need some kind of general counsel experience. We've seen too many times to where smaller companies have great outside attorneys and great outside law firms that they work with, but it takes them, it's so expensive that they really only go to them on the big deals. And we've noticed that things get missed. So we've started a company called On Demand General Counsel, where we basically act as fractional general counsel for smaller companies, and to get a couple of 30-plus year attorneys to be able to do some of those things. And the nice thing is we pat ourselves on the back because we can do it for a heck of a lot less than the guys in the big law firms. And so that has been a lot of fun. So that kind of gives you my background and how I got to where I am. I'll let Wade tell you real quick about kind of what his experience is, and then we'll jump in and tell you some things that we've learned.
Yeah, so similar background, not from Idaho, but actually I live in Boise. So thanks, Jeff, for the intro. Did law school back in Connecticut, worked in Manhattan, Massachusetts, Connecticut, came out to Boise about 20 years ago, focused almost entirely on commercial real estate, land development. I've spent the last 7 years doing strictly land development in the Boise area. So I've put about 750 lots online. We got in 2024, I got approvals on a little over 1,000 multifamily units with about a couple $100,000 in our couple 100,000 square feet of commercial real estate as a principal, but also as an attorney. So I think with our different backgrounds, we kind of bring a unique perspective to land development. We were laughing to the quote. I have one of my clients is a multifamily builder, and he says he loves the smell of wood. I'm a dirt guy. I love the smell of dirt. So it's something I'm really, really passionate about is land development. And so we kind of wanted to bridge a little bit of the legal issues, but also just the practical issues of going through a deal and kind of start from A to Z. Steve asked how long we wanted to talk. I could spend 7 or 8 hours talking probably just about title reports.
We won't.
We won't. But this will be a lot more fun if you ask us questions. It sounds like we've got a really diverse group from GCs to real estate agents to land developers. So we've probably seen it. So if you have any specific questions or if you want us to drill down on any particular topic a little deeper, just ask and we can do that.
Yeah, Wade's in, like he said, he's in Boise. I'm in Salt Lake, and it's been kind of fun because we both had lots of experience in both markets. To me, it's always kind of like the big brother, little brother thing. Boise and Salt Lake are tied, together in so many ways and are very similar markets. People ask me, what's Boise like though? We hear such good things about it, and I'm like, it is a mixture of all of the good things about Salt Lake and some of the weirdness of Portland. I said it just, is kind of a mix. It was an awesome place to, for us to raise our families, and he stayed and I'm down here and I absolutely love it down here, but yeah, there's things about Boise that I miss. So here's kind of the agenda. We're going to talk through about, tying up the dirt and tying up the property and some considerations that we need to look at there. What are the different ways that you do that? When do you use a purchase agreement, or are there other mechanisms to use through that? And then earnest money and building smart contingencies. And we'll probably spend quite a bit of time on that, as well as terms that, will allow you to walk away if you need to, and those types of contingencies. And then we'll spend a little bit of time talking about title reports and easements and surveys. Last month there was a lot of conversation, on the civil engineering side and interaction with the cities and those types of things. So, you heard about a lot of those things, and we'll touch on some of those that, we feel are most important when you're trying to protect yourself, especially through title insurance. Buy land, they're not making any more of it, and that's the truth. I was just listening to KSL on my way down, and we've all heard, how Governor Cox is on this. We've got to have more housing starts, and the state's going to take over, the zoning and take some of these powers from the city if the cities don't get their butts in gear and cooperating and making it a little easier to be able to do some of these things. And that the governor's goal was, I want 10,000 new, starts in 2026, and that compares to with what they said was 5,800 new housing starts in the last 2 years combined. So, there's a lot of work and there's a lot of, changes that are going to have to be made. But, if you find a piece of property, the traditional approach is, you buy it, and then, you figure out what it is you're going to do with it. And that's probably an old school approach now. I mean, when you look at it, because there are just too many things that you have to rely on when you're trying to work with cities, you're trying to make things pencil out. And so really, I mean, what our background has seen is, trying to work a deal to where you can get as much time as possible. Time, if you're on the buyer side and the developer side, time is your friend, and time is what you need the most, because you know how long that it can take when you're doing everything from working to cities to getting certain reports that you need, all sorts of contingencies. And so, time is kind of that primary driver, and with the hope of negotiating a deal where you can get your entitlements and get a lot of that taken care of, while you're still under contract, but maybe you still have some outs on some things.
Yeah, so I've done most of my deals under the structure where I tie up the dirt, get entitlements, and then close at the end of entitlements, which I think probably a lot of you, that's the typical structure. So you're eliminating that entitlement risk. I think the most important thing is meeting with municipalities. I can't tell you the number of people that I've met or seen deals that have come across my desk, and they say, oh, well, I've got, it's 12 per acre, I can get that. They haven't met with the city. They haven't talked to anyone. I always start with the city first, not necessarily for a pre-app, but they don't want to waste their time working on deals that just simply are never going to get approved. So meeting with the city out of the gate, there's always a planner. There's someone that knows something about the property, especially if you're focused on infill properties. They have an idea. They're going to tell you exactly what your no-goes are going to be, right? So that's, I think, the most critical thing. I think the other thing where people kind of fall short in the kind of what I'll call pre-contract is meeting with all the other agencies. Literally the most powerful agency that we deal with in Boise is the road district, the highway district. They cover all the roads. And guess what? When the city tells you one thing, oh, they're going to give you this. I do this with my kids. It's trust but verify. Trust but verify. Yes, because I don't know how many deals I've looked at where they've said, oh yeah, the roads are this, that, and the other. And that's not the case. The other one is, and I know you have it here in Utah, is irrigation districts. That's also one of my biggest barriers in development. So meet with them, call them, talk to them. They'll tell you. They're going to tell you what the right-of-ways are. I'm also surprised at a number of people who just don't look at the property. So I looked at density is a big one. You'll have people bring deals and they're like, well, it's 10 per acre, and I can get 100 lots because it's 10 acres. Well, how much are you going to lose to roads? What's the open space requirements? On average, you're going to lose 22% of that property. It's not a 100 lot deal anymore. So that's why I always say, do a deep dig on this. I think the other thing too is just have them guide you through what the code requirements are going to be. What is it that they have a vision for? So a lot of times you'll have what's in the code, what's in the comp plan, what's in the future land use plan. Have them connect the dots for you. What is their vision for what's going to happen with this property? Because especially on infill projects and even ones that are expanding, they have an idea. Is that a mixed use project, or is it just a multifamily project? Those are two different things. So that's why we wanted to focus on that, because I think you really have to understand that aspect of it. And then the big one is timing. Ask them, hey, how long if it's an annexation and a zoning, how long does it take for you guys to process that? 6 months, okay? Add 3 months to that. Or is it 12 months? Or what's the sentiment of council right now? If I've got to go through planning and zoning and council, are they a go right now on development? Are they not? That's the big issue we have in Boise right now. I know you guys have a lot of it here. Is you read the news articles, oh, we're pro-development. Yeah, but are you? Are you really? And what burdens are you going to have on that project? They're going to tell you, get a feel for that, because it's super important, especially on annexations. That's always the biggest hurdle. If you don't have a pro-growth council, that needs to be part of your timing and whether or not you want to do the deal. I always tell people, for every deal I do, I've probably looked at 10. And this is where about half of those die. is at that meeting right there. So I think that's super important.
I think when, it comes back to it and talking about tying up the dirt then, the reason we kind of give you some examples of some of these things is if you can buy the property and pay, the buyer and get them out of the way, good for you, more power to you. But that doesn't happen very often anymore. And so what you really need to do is you need to understand all of these things, because what that ties back to is your time, which is your primary driver. How much time do I need to try to build in to a purchase agreement with somebody before I start losing, real money? Now, obviously, you're always going to have during your due diligence period, expenses that are probably going to be sunken and lost costs. But to the extent that you still have some contingencies to be able to get out of a deal if it's not going the way that it needs to, and that you're not stuck and you don't already have hard earnest money that you're going to lose on this thing, that's really where you should spend a lot of your time and a lot of your focus when you're negotiating a purchase agreement. Like Wade had set up here, he says, all sellers have a number. Give them that if you can make the deal pencil and negotiate the time and the outs. So I think sometimes we get so focused on what the purchase price is going to be, which obviously is important because the deal has to pencil for you. But we sometimes overlook the ability to build in, the time frames that we need, so that if things don't go as we're planning or as we expect or hope, then that we've got a way to be able to back out of this deal. That is a hard thing, and it's a completely different perspective when you're looking at it as a buyer versus when you're a seller. When you're a seller, what do you want? You want the shortest due diligence period possible because you want them locked in. You want that deal and you want to know that this deal is going to go. You know what? When you're a buyer, you want the exact opposite. So it is that negotiation of being able to try and find where is that sweet spot that's going to work for both of us. But if you find yourself, especially in today's environment, with not enough time from a due diligence standpoint, it's something you really have to take into consideration when you're underwriting the deal. Because you really then, if you're going to go with a shorter due diligence period, depending on what some of the things are here that you're dealing with, you have to be prepared and understand there's a very real possibility that I could lose some real money on this deal if things don't go the way that I thought that, as quickly as I thought that they were going to go.
Other way.
Oh, I guess it's because I have it upside down. There we go. Okay, so how do you do that? What is the means for doing that? Development is a funny thing, and I have seen it throughout my career. There are so many times where you've got somebody who has got this piece of land. It's been in the family forever, or, they've held on to it forever. It's in the path of development. It is the perfect piece, to be that next great development project. But you're dealing with somebody who obviously isn't a developer, and the current owner or the seller. And sometimes they understand and think, oh, I know there's a lot of upside in this deal. And on the other hand, you're looking at maybe a developer who's saying, I don't necessarily have all of the money that I need, so if I can get these people over here, these owners, to contribute the property, and we go into it together, that can be a great solution in theory and on paper. On the other hand, landowners that don't understand the process and are doing that can be some of the biggest pains in the butt that you will ever, deal with. And a lot of it is just because they don't understand it. So it doesn't mean that it's not an option and that you shouldn't do it, but it takes on a whole new set of considerations as far as how is this deal going to work? Who's going to control this? What say are they going to have? And so, that's something that you need to take into consideration, when you're doing it. The cleanest way, just like on the first slide thing that we talked about, if you've got the money, you can go in and buy the property, and you don't have to worry and negotiate all of these things. That's great, but that just isn't reality most of the time now. And it may not be reality when you're looking. You may need to have somebody contribute the property. But if you're doing that, the easiest and best way to do it still is going to be, through a purchase agreement with some well-negotiated timeframes, due diligence periods, and those types of deals. Wade's had some experience, with some of these others, and can tell you some of his horror stories.
So assignments, I'm a little mixed on assignments. So the first scenario is, I see it a lot. Real estate agents are tying up dirt, and then they just want to get an assignment fee and make, $90,000, $100,000 and kind of be done with the deal. Those are good. It's a good way to get dirt. The problem is you've missed the opportunity to negotiate the critical terms. So can you really get a deal that works for whatever your model is? The second scenario I've had, and it's 3 deals in the last probably 3 years, hands down worst deals I ever had. So there were other developers that were struggling with deals, wanted to give me an assignment, and then they want to do the clawback, right? They want to be able to step back in if I can't get it over. Hands down, they made the worst partners ever. Mainly because they still wanted to drive the deal, but that's my job, right? So I'm not a big assignments person, but again, it is a great way, but just think about that. If, and I would spend a lot of time on the assignment. I had one agreement that was it was a 10-page assignment. Some guy out of California, it was a developer, came in, couldn't get the deal done, stepped in. We had great terms, we had lots of time, but he was a bad partner. He wanted to know everything because he had some step-in rights at the end, and it was just a pain in the butt. I had to manage him more than anyone else. So I would caution you on assignments, but they are a great mechanism. If you're not the first one to the dirt, okay, if someone's negotiated a pretty good deal, and I think it goes back to your comment about earnest money. Sometimes the assignment's just the cost of doing the deal. But the other thing that I've seen is developers that are trying to get someone else to come into the deal, their assignment fee, they want that to be the equivalent of what their profit would be. And it's super hard to make those pencil. If you're all of a sudden burdening a project with another $500,000, I had some guy wanted a $500,000 assignment fee. It just isn't going to pencil. And I think you guys have a lot of the same economic issues we have in Boise. Is these deals are expensive and it's hard. The margins are compressing. It's hard to put deals together. You can't just throw on another $500,000. So those are the things I would caution about. On the options, not a big option fan. They really have a pretty limited application. With options, I think my question is, just go into contract, right? Go negotiate the terms you want to get that deal done. Because an option, all that does is buying time. Lock it up. Do the deal. If you can't do the deal, walk from it. So that's kind of our perspective on that. The JVs, Jeff kind of softened my language. Landowners make the absolute worst partners if they're not developers, if they're not in the business. It's just, I've done a couple, and it's a nightmare. So when I say JVs, you have two kind of issues. Am I going to joint venture with the landowner? Do it in an LLC, and we're going to talk about that in a minute. A lot of people try to do joint venture agreements, and in my opinion, they're usually wholly insufficient because you really can't embody what a deal looks like and who's doing what in a simple contract. And that's essentially what you're trying to do. It's kind of almost like a non-committal, we're JV partners. No, you're either partners or you're not. If you're partners, do it in an LLC structure. That's where you're going to get all the protections. That is your game plan on how you're going to do that transaction. And every joint venture agreement I've ever seen, they don't cover half of the scenarios. So that's kind of our input on that. Again, landowners make bad partners.
Yeah. So in talking about the LLCs, and I think this is one thing that we probably want to spend a little bit of time on, is first off, if you're doing a deal, you always want to set up a separate entity to be able to do it, and that's for lots of different reasons. But the main reason is just liability. protection. If you've got a couple of different deals, that are going on, you don't want problems over on this one necessarily affecting the problems or all of the good things that are happening over on this one. Now, it's not that simple or that basic, because you've got guarantees and and all sorts of things that make it so there's the effect of what's going on one, that may affect another. But in general, you should do each of your projects in a separate LLC for liability purposes, for protection, and to be able to just isolate your projects and your different assets from each other. But one of the places where we probably want to spend some of the most time, and I think is one of the most important, because in my experience it gets the most overlooked, is everybody gets so focused on, okay, well, we've got this property, we've got to get it under contract and we've got to do this, but you've got, maybe multiple partners that are involved on that. Okay, we're going to form an LLC and we're going to come in, we're going to do this, and yeah, I'll put this much money into it, and okay, I'm going to provide the guarantee, I'm going to do these types of things. But it's like, we know that we need an operating agreement that's going to govern how we're going to act towards each other, but we'll get to that. We'll get it done. And so many times it doesn't get done. And your operating agreement is, you hate to say it, but even in the world we live in, it's your prenup. It is your prenuptial agreement that's going to explain what's going to happen and how these parties are going to relate to each other under different scenarios that may or may not happen, but it's very likely that some of them are going to happen because that's just kind of the way that it works. So when we're talking about an LLC, one thing in going back to your purchase agreement, if you're going to do it in the name of an LLC, or sometimes if you need to tie the property up quickly, make sure that you have negotiated an assignability clause of some sort. Now, if I'm a seller of the property, I'm pretty careful about wanting to know, okay, who's buying this and who has the ability to be able to perform on it, because I don't want you as the buyer just to be able to willy-nilly, assign this to whoever it is that you want. I have entered into an agreement as a seller. I've entered into an agreement with you for a reason, because I've done my own due diligence as a seller and I'm confident that you can perform on it. And I don't want you to be able to have the ability to assign this contract to somebody that I'm not comfortable with, whether or not they do have the ability to perform on it. So
to add to that, as a buyer, I want the ability to assign that. Maybe Jeff comes in and says, hey, I decide, hey, I'm a little short on cash. You want to come in as a partner? Yeah, let's set up a new LLC that I don't control. So I like that ability to be able to assign it to whoever I want. And if I can get a fee for it, hey, that'd be even better. But the way I address that issue is you can also limit that assignment to entities as a buyer that I control. So I've got, I don't even know how many LLCs that I'm involved with. But I like that. I have a kind of a master LLC that I use, and a lot of times I'll tie up dirt with that, and then I'll go set up a project LLC. So I can put some language in there that says, hey, it's an entity that's controlled by Wade, and then I'll shift that agreement over. One of the things to remember, though, is make sure you actually do that before closing. I see that. I've actually done it. You're like, oh, crap, I never assigned that contract over. So just make sure you get that done.
And one thing, and I'm going to tell on Wade here a little bit, and he doesn't know that I'm going to tell this, but the importance of being able to do this, and as we now start talking about, who should be the manager, what powers should members have versus managers, and so much of it depends on, what the prior relationship is between the members and the people that you're doing business with. There are going to be some that you're just more comfortable with, and allowing the members maybe to have more power than somebody that, you know, you're bringing in an investor or somebody that you haven't dealt with very much, and you are going to be the manager of that, and so you want to be able to maintain, you know, the powers that you have. But you just never know what you're going to get or who you're going to get on the other side of things. And I can remember when Wade first started doing this personally, you know, himself, and I think I was still in Boise at partner at Givens Pursley at the time. And he told me what he was doing, and he told me who he was doing it with. And I went, what? Why? You know, no, it's going to be okay. It's going to be okay. But, you know, I told Wade, I said, you better have a dang good operating agreement on that thing. And it better be designate who has the powers to do what. And I think he was the manager on it.
We were co-managers.
Were you co-managers?
Yeah.
But, and it didn't turn out well.
No.
And it didn't turn out well for the exact reasons I said, Wade, why are you doing this with it? Well, it's a good deal and I think I can control it and blah, 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 blah. It all comes down to the power of your document. And even when you've got a good document, you know, that one ended up in litigation. To be able to do it. So these are things when you're working with setting up, you know, that entity that is going to own this property, figuring out, okay, what are the responsibilities of going to be of each party? Who's going to be responsible for doing what? If it is going to be something that's going to be manager managed, and you're going to have members in it that are going to be more passive or less active, you know, in the day-to-day operation of this, you know, clearly designating what's going on in that situation. You know, Wade pointed out here, he said, you know, don't be a direct manager as an individual, you know, set up a management LLC. Again, just for the purpose of, depending on who it is that you're dealing with, both as members, you know, protect yourself individually. And by putting it into an LLC, you have a much greater chance of being able to protect yourself from, you know, the things that you do as managers, from gripes and complaints and lawsuits and, you know, from potential members, if you're putting that into an LLC and you're making sure that obviously you're, you know, maintaining those organizational things. So,
That management LLC, is that typically your parent parent LLC?
Yeah. And I might set up different ones depending on who my partners are, for tax purposes, leveraging some costs, expenses, reducing what I have to claim as income. So that can be sometimes just me under that LLC, but always, or it could be a group of us, but always have some structure that insulates you between you and the project LLC. I mean, use the law. It's called piercing the corporate veil. Super, super hard to do in Utah and Idaho, and actually in most states. So use that. But I can't tell you the number. In fact, I have a really good friend who's a multifamily builder that I mentioned earlier, and he actually got sued personally because he was personally named as the manager, and the deal went sideways, and now you've got all of your fiduciary duties, duty of care, duty of loyalty, all of it. I mean, it's going to fall on you. So you want to do that for your own personal reasons. I think the other thing too is I raise quite a bit of capital, and so I like investors that sit down and shut up and don't touch anything. So that's where this becomes really important. Obviously, investors need to have some say in that. They should want to, and you want them to, but you need to spend some time on what that really looks like through the life of a project. So call it cradle to grave, a project that you take all the way through to final lots. Think about that. What do you really want to have them say? Because it can't. I've never had a project that's gone smoothly, right? Like they all have something goes wrong, or you hit these hiccups and stuff. I like to be able to have the ability to make a lot, if not most, of the business decisions that are the day-to-day stuff. I don't want to have to go to a partner that I've got out, hey, you know, we're filing this application, or we've had whatever. So just put some thought into that, because I think it's super important. I think the other thing too is spend some time on capital call provisions. Mm-hmm. You should have an LLC that has capital call provisions. So capital call provisions are, what's your name? Mike, guess what? We need another $1 million. How are we going to do that? You know, a lot of people have these basic provisions, and they're really, and the scenario is maybe you're stretched out on 5 other deals. You don't have a $500,000 bucks, right? That's fine. I'll come in with $1 million, but how mechanically does that work? So think about the scenarios of, hey, if Mike and I, one of us can't come up with the money, and I think that's the most important part of a call provision is how does that flow through? And more importantly, if I'm the one that's got to fund it, someone's got to come up with the money. Well, if I fund it, what's that do to my ownership interest? If I bring in a partner, what's that do to our overall ownership? And by the way, what's that partner now? Is he a member or is he a manager? So it's a really, really critical provision that I don't think a lot of people spend a lot of time on. I have one that I use in my operating agreements. It's the call provision is now an addendum. It's a 1.5 pages, single spaced. And it covers just about every bad scenario that I've seen on my personal deals as well as clients' deals. So spend some time on that because I think it's super important.
And Wade and I have both been with, heading the legal for, pretty major real estate developers and investors on these things. And it still is, that is one of the areas, look back at post-COVID and when, nothing was underwriting the way that it was supposed to anymore. And you don't think capital call provisions became a big deal all of a sudden? They did. They became huge. And you start figuring out, I wish that had been written a little differently, or we wish we'd done that, or wish we had contemplated that. I'm telling you, sometimes it sucks being a lawyer because we're negative and we're naysayers. But that's what you need us to be, at times, because you need somebody to look at it, hey, this is a great project and this is exciting. What I'm here to show you is if things don't go as you plan, what are the things we've got to work out and the things that we've got to think about?
Yeah,
and that's where your operating agreement, becomes key. And in my opinion, and I think Wade's, is one of the areas where it's overlooked and pushed to the side a bit too much sometimes.
Yeah, and the scenario is Mike and I are just stoked. I found some dirt. We're going to go tie it up. We're going to get this thing done. We're going to make some money, right? Like we're not thinking about, man, what if I hate his guts in a year or halfway through this project? Or what if I can't fund and those types of things. So it's a really, really important document.
Yep.
Question on that. What about an individually owned LLC for the project? Is
Perfect.
it still good to have another management LLC or?
So on those, I have like a single asset.
Can you repeat the question?
Oh, sorry.
Individually owned LLC?
So individually owned LLC. So it's Wade owns WT LLC.
Yeah, it owns land.
Yeah, and I've got some dirt in there. So you should always have it. And the scenario is, what are you going to do if you have to bring in partners? So it's kind of twofold. I have a super simple operating agreement. It's a single asset, single owner, but I still structure it as a manager manage. I'm the manager. I'm the sole member. But I'm thinking going forward is I'm just going to keep using you, Mike. You want to do some deals? I'm still thinking that, hey, I've got some other deals or I've got other partners. I mean, there's 1,000 different reasons, but the biggest one too is just you also personally want that corporate shield in place, right? Some kid goes onto the dirt and is jumping his BMX bike or whatever and gets hurt. Guess what? You're getting sued. So it does add in a layer of protection. So it should always be there, even if it's something that you own personally as an individual. So my wife and I have an LLC. It owns dirt. It's the two of us. We could probably own it together, but it's there for a reason. So hopefully that answers your question.
It's a good extra. So earnest money and building in smart contingencies. Earnest money and contingencies, going back to the purchase agreement, it's one of those things, and so much of it is based on whether you're looking at it from the perspective of the buyer or the seller. I mean, if I'm the seller, I want as much earnest money as possible. I want it to go hard as fast as, possible. I want as few contingencies as possible. If I am the buyer, once again, time is my friend, and I need that time depending on what kind of deal that you're doing. When you're doing development deals, it becomes even more important because you are so dependent on things that are outside of your control, okay? City approvals, other regulatory agency approvals, all of those types of things. And so it may be that on a simple transaction, or, for instance, if you're buying a house, I've got, 30 days due diligence to be able to have an inspection done, make sure, that there aren't problems that I'm contemplating with the house, and to make sure that I've got my financing lined up, those types of things. And then boom, I approve the due diligence and I'm bound. And your earnest money then at that point becomes non-refundable or goes hard. When you're talking development deals, there are a lot of different milestones that you need to look at. And so what you need to understand is a lot of the things that we've talked about already, what needs to be done in this particular transaction, and what's a fair way and a way that's beneficial to me as a buyer to be able to set up that earnest money, so I've got as little of it going hard, at whatever those milestones are. So, like I said, the development realm is a little different, but I'll just give you, even if you were buying a developed industrial building. You're buying a developed industrial building, and you may have a situation to where it's like, okay, I'm going to give, a $2 million property, purchase price, I'm going to do 3% down, we agree to as the earnest money. Well, then what are the contingencies that are built into that, and how did I do that? Well, it may be, okay, I think that I can get through due diligence from a standpoint of looking at the underwriting of the actual financial operation of the property, in 30 days. I can get through, the leases, making sure, underwriting, who the current tenants are, those types of things, that are all going fine. Maybe even I can get, a phase 1 environmental assessment, done during that period of time. But then maybe there's some other things that I can't get done during that period of time. The financing. Maybe I can't get the financing done during that period of time. So maybe I've got a 30-day due diligence period or a 60-day due diligence period for all of these things, except for the financing that's on it. Maybe it is a property that does potentially have some environmental risks because of the type of use on it. Maybe I can't get that done within the 45 days. And so what you look at is what are the things that have to be done in order for me to fully commit to be able to buy this property, and how long do I need to do each of those things, and can I stagger them to make a seller more comfortable, to go with me. Because the last thing you want to do is, if you've got a property and, there's a lot of interest on it, you don't want to be the guy that just says, okay, yeah, here's my purchase price, but I need 120 days due diligence. Where there's somebody else who's saying, hey, I need, I can do the same thing, but I think I can do all my due diligence in 60 days. Those become the types of things, other than price, then, that become important to a potential seller. So you want to put yourself in as good a position as you can, so that you can get the deal if it's the deal that you want, yet still protect yourself. So it may be that you have these different contingency periods and due diligence periods for different things. That's where understanding what your property use is and what all of those possibilities are, so that you can kind of work backwards and think, okay, here's how much time I'll need to do this, here's how much time I'll need to do this. And then also, if there are some of them that you just kind of get to the point to where it's like, you know what, I really want this deal, but I'm not going to be able to get that long of a contingency period or due diligence period on this one particular item, so I'm going to have to give on that one. And then in doing that, then maybe you look at the earnest money and the way that the earnest money then relates to those contingency and due diligence periods, and see how you can tie those up. You know, best case scenario for a seller is, okay, I've got, you know, $500,000 or $200,000 in earnest money here, and the seller's saying, okay, you can have your 30-day due diligence period, but then that all goes hard after the 30 days. You can still have your contingencies, you know, that you could still get out of the deal, but the earnest money goes hard at that point, which in other words means that I, as the buyer or the seller, get to keep that earnest money even if some of those other contingencies don't work out for me and you walk away. And I look at that as a cost of doing business. Or I can divide it up and say, okay, after then that first 30-day or 60-day period, for these easier things that I can do during due diligence, then maybe at the end of that, maybe, you know, 100,000 of it then goes hard. And I still have, you know, another 100,000 that is sitting out there, then that is tied to, you know, some of these other due diligence contingencies that I've got. The point being that you want to be able to understand, what do I need to get done in this deal in order for it to close, and how do I put as little money as possible at risk and still be successful in being able to get the deal. And so those are, you know, those are things that you need to think of and you need to be aware of.
Another thing on some deals is sometimes you want to think outside the box. I like keeping my money. So even if I'm comfortable, let's say paying $250,000 in EMD, stage it out. At the end of due diligence, you'll pay half that. File the application or have one of the meetings. Another trigger, another trigger, another trigger. Just a little bit of a way to maximize your capital internally, so you're not plopping down $250,000 and, more importantly, losing it. On due diligence, my feeling is in about 2 weeks, I know if I've got an issue with a piece of dirt or not. I ask for 120 days. So it gives me two things. It gives me additional time to, you know, get the title report, do the phase one, do the geotech, see if I've got any gremlins that I need to deal with. But more importantly, it goes into the story of why I need so much time to close. Because you got to remember, you're talking about potentially a year transaction with someone. By the time you get all the way through entitlements, give yourself a little extra time. Like, it kind of builds into the story. It's going to take me 90 days to get through due diligence. Then we're going to do all this. It's going to take this long to get with the city. Like, time is your friend and time is your enemy on land deals, right? Especially if you're dealing with the municipality.
And see if you can build in, you know, to your purchase agreement extensions then that will allow you, okay, it didn't go the way that I thought it was. So do I have the ability then to be able to extend that due diligence period longer than originally was set forth in the purchase agreement? And to do so, you know, do I need to come up with another $25,000 or $50,000 or whatever it is of earnest money? Lots of times for extensions, they'll give you, you know, a seller may be willing to give you those extensions, but they also want that money to go hard, you know, at that point. And so you just need to understand what could go bad and how can I
offset it.
You know, offset that and contemplate that. It's 20 till, and so I want to make sure that we have some time for questions. Anything else you want to say on this?
What's the next one?
We talked about probably a lot of this. You know, we just talked about building extensions into the deal, contingencies to tie the earnest money to different triggers and milestones.
Probably the two new ones are the last ones. One of the concessions for, I don't know what it is about landowners, they really want those documents. If you walk from the deal, give them to them. You're not going to need them. Right? You're not going to need the geotech.
They're already sunk costs to you.
Yeah, they're sunk costs. So
it's always a good carrot.
But you get a ton of good faith with that. I think the other thing too is, as a buyer, you're typically dealing in Idaho. I'm dealing with farmers 9 times out of 10. Right? Communication is key. If you've got a contract that's got a life cycle of 9 to 12 months, and you've got a bunch of variables that you can't control, i.e. the city, and going through planning and zoning, update them. all along ways. Give them those documents. Send them the geotech. Send them the phase 1. Do they know what they're looking at? No. Doesn't matter. Send them the record of survey. Send them a copy of the application. Send them a copy of your presentation for your planning and zoning meeting. Send them a copy of anything, because that is, knowledge is power. And more importantly, they know you're doing something, right? Because that's always the fear is, oh my God, I tied it up with Wade and he's not doing anything. And you may need that good faith if you get to the end of your contract and you really do need to renegotiate that deal, either on price or timing. I've gotten more, I would say more out of that right there, just simply communicating with people. And it's same with your investors, right? Update, 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 update. Doesn't matter that they don't know what they're looking at. Just update them. They know they're doing something. It's so critical when you have a what I'll call an unsophisticated land seller, and I would say even sophisticated land sellers, as long as they know you're doing something, because in their minds, you're adding value to their dirt, right? So, but it's really important. I think that's probably the biggest one.
You know what, and one thing that's kind of interesting, especially as we've both done a lot of work in both Idaho and Utah, a lot of similarities between the markets. There are a couple of big differences, and especially when it comes to development. Wade said, you know, I mean, up there, lots of times I'm dealing with a farmer or something. To me, it's always been amazing because in Utah, you're always dealing with smaller parcels, smaller tracts of land. In Idaho and even in the Boise area, you're usually dealing with much larger parcels. And your developments, and you can see if you drive through the Boise and Meridian area, you know, they have these big, beautiful subdivisions with extensive landscaping that are all one. You know, it's very different. Where here it's, you know, you start to see some of that a little more back out in open areas like, you know, the Daybreak area and west side of the Salt Lake Valley and west side of Utah County. But I always used to laugh because when you're dealing with, you know, the different landowners, you know, both of them essentially are kind of agricultural states. But I always laugh. Idaho is, you know, a big, huge, you know, $250,000 John Deere tractor when you do it, compared to Utah's a riding lawnmower. When you know, when it comes to agriculture. I mean, it's just, they're two very, very different economies in the way that it is. Agriculture in Idaho is just on a much, much larger basis, but that translates over onto the development side and, you know, and who you're dealing with. So you may have to be putting several parcels together more, you know, down here, whereas up there, you know, you don't usually have to deal with that as much. So just one
quick example on the updating the landowners. I literally had this happen end of last year. Had a multifamily project. We pulled 5 owners together and got into a situation where it was, I called it the road to nowhere. And man, I just couldn't get any traction. So I updated the owners, and the one guy's like, well, have you talked to the mayor? And I was like, well, we tried, you know, we have to be a little careful. And he's like, oh, I'm his treasurer for his campaign. I'll just call him. And magically, staff called me, and all of a sudden, the road to nowhere was not that important to him. So that's kind of just a value of communication, right? And for whatever reason, I had no reason to ask him, you know, do you know the mayor? But he's like, oh, I'm the treasurer. So those types of things, I think that's key on communication. We didn't want to
talk about this because another overlooked.
Yeah, we could do a whole masterclass just on survey or on reviewing documents, right? So people think title reports has all the information. It does not. Okay, start with the survey, and you should learn how to read a survey if you're doing any kind of land development. I think it's hands down the most important document. The reason why is when you look at it, you're going to find all the what I call the buried people, right? It's got all the grave sites in it. But more importantly, it gives you all of the legal instruments, usually on the bottom right side, that the surveyor used when he did the survey, right? So a title report doesn't have all the information. So if you look at that B2, those are the exceptions. Those are the things that aren't covered. There is a common misperception that that's everything that's on the land. It's not. Have a great relationship with your title company. So I typically will start with the survey, and I call the title company and I say, I need every single one of these documents. They'll pull them for you. Are they on the title report? No, some of them aren't. Some of them are, but some of them aren't. And if you look at that title report, you go to B2, has the exceptions. They usually have a link and you can pull up whatever, if it's an easement or what have you. But I think that's, as a buyer, super important to start with survey. Understand what a title report is. It does not cover everything, right? And there's all these exceptions. If you look at the general exceptions, they're basically saying, we're not really covering very much. Okay, go through the process. And this is, I think, is where an attorney is pretty important. All of it's negotiable, right? It's called title objections. I have usually a 5-page template. Everything I ask them, all of those general exceptions, no, I ask them to get rid of them. Guess what? They will get rid of them. Premium might go up a little bit, but that's okay. And then the second biggest piece is endorsements, right? So you get all of these endorsements to cover these things: zoning issues, property improvements, road access. So I think you'll all get the presentation. So take a look at that, because I think it's really important to understand what the title report is, because people have the common misperception. If you go look in that document, you will find everything that encumbers that land. You will not. So it's super important to understand that, because that's really what's going to drive your due diligence. Because when you're looking at your due diligence, you need to know where those things are, because you're going to have to clean title up at some point, especially easements, those types of things. Or if you have an irrigation district, they have an easement, they may ask you for more, those types of things. You got to know where the bodies are.
And your lender's going to make you anyway.
Yeah.
So, you might as well understand, almost looking at title from a lender's perspective as well, right from the very beginning, because, they may get on and look at some things and, they have some additional requirements.
And then I put in the endorsements that apply to a lot of land development. So be looking at those, because it is really important. The percentage of claims on title policies is really, really small, but these things become really, really important if you're that 1 or 2% of people who all of a sudden have a title issue down the road. And guess what? It's down the road. It's when you're trying to sell it off to Lennar and you got them finished lots finally. That's when this stuff comes up. You want to deal with this up front.
Yeah. That's basically it. I mean, I know we covered a lot of stuff, and probably a lot of it was just scratch the surface, and a lot of it is probably things that as you have already gone through and done deals and negotiated purchase agreements and some of those things. But they're also good reminders, and we'll put in our push a little bit for why you should have good counsel that knows and understands what they're doing on these things, because once we've all done them, we think, oh, okay, I've seen this, or I know to do that, or I know to, but again, we're the naysayers, and lots of times we've seen things in other deals that may be applicable here that you haven't seen in a different deal before. And so that's where having, I think, good and competent legal counsel that understands real estate and development is probably very helpful.
Yeah, I think I would add to that. There are, from a strategic perspective, there are times in particular city council, I have a land use attorney that I hire sometimes, because guess what? I need that guy to be the bad guy. Or there are a lot of significant legal issues, in particular if you're really threatening to sue them if they don't approve your project. Sometimes it's good to have counsel do half of the presentation, or come in and do 5% of that presentation, if for no other reason to send a message, hey, I'm pretty serious about this, and we're considering litigation, put it on the table. But have a good counsel, and have someone that knows title reports. It's a big one.
Yeah. Questions? Yeah.
I have a question on title exceptions. I appreciate you talking about that. How easy is it to get those removed?
So easy. So easy. I personally try to use the same type. If the seller is amicable to it, I will use this. I have one lady that I use, and I use them. It's Pioneer Title in Boise. I use them for everything if I can. And it's because I could literally call her on my cell phone right now and say, hey, I got an issue. almost all of them will get waived.
I'm dealing with an abandoned railroad right of way and a property in Cassia County. It's a big ranch, and the title company, they won't provide.
I was born in Oakley, so
Oh,
I know
yeah.
Cassia County. Yep.
So they won't provide legal, there's an exception for legal ingress to the property because of this
Yeah.
railroad that was abandoned and
Yeah.
So the one thing I have found that's helpful, now I think this is where it's helpful to have an attorney involved. I've elevated it to, I need to speak to the attorney at the title company. And that's usually someone that you can really kind of, they're going to get it. And more importantly, when I say they're going to get it, they're going to understand the real legal exposure, and then let them go back and say, okay, look, let's make a business decision.
Or here's the workaround.
Or here's the workaround. So on something like that, that's kind of a little bit out of the box too. So I could see them kind of being like, ooh, no, we're going to tuck that underneath there. And I don't think there's really any.
Lots of times they'll just, they'll throw those exceptions on because that's what they are, and they're protecting themselves. Some of them are, when you get into, the good commercial title people, they understand that there's going to be some pushback, and that's when they'll start working with you for, okay, how can we work around this, or what do I need to do to get this removed? And sometimes it's, well, if we just had a document that said this, or if we had this or something, lots of times, but unfortunately, they're going to throw everything in, at the beginning, and you get to weed through what's going to get taken off. That's right.
Yeah. The other thing that really helps, it's also having someone at title that just does single family residential stuff and has never done a development deal, a land deal, a subdivision. The couple people I deal with, they do almost exclusively subdivisions. So they know it, they understand it, they know, they can go kind of fight those fights internally. Because guess what?
And that's another one for the purchase agreement.
Yeah.
As the buyer, especially if you have a relationship, negotiate and you put in who the title company is going to be. And there's a lot of times, especially in the big deals when I was at PEG and when we were in Boise DBSI and stuff, it was just, that could come close to a deal killer for me. Yeah. If I didn't get my title company, because I was confident enough with them that I knew that I could work with them and I wasn't going to get to run around on some weird exception.
And 9 times out of 10, the seller's picking it because it's their nephew or something. You want someone that does your kind of deals working on your title.
Yeah.
Do you get involved with development agreements as far as structuring contracts? Doing that? Any advice on?
I think my feeling is, the code may require that it's, in Idaho, it's the code section is whatever DA. So it's like, all right, great, I need a development agreement. Cities are usually pretty good on new ones. I think the difficult ones, and this is where due diligence comes in, if there's an existing DA and you have to get it modified. So I had a scenario where we were not going to have to take our project through all the way to city council, but the DA modification required it. So it's just kind of understanding those little nuances. All that the DA is really doing is kind of memorializing all of the kind of four corners of what your development is going to do. And if there's any asks or any, basically things that you need to get done to get that development agreement. But that's the only time I ever really have issues with that, is you got to modify it, and then you got to, so throw that out there.
Who do you recommend for title in Utah?
Yeah.
Oh.
I can tell you who I would recommend.
That list probably like that.
Yeah.
That understands development, because anyone can do a single family home.
Yeah, anybody can do a single family home.
If I don't know, I haven't done any deals down here. I've looked at deals, but I've never done a deal. Call your title company. I don't know what you do, but if you've got someone that you talk to, say, hey, can I have someone work on my project that does, single family residential subdivisions, preferably ones over 100 units, or 100 lots, those types of things. Or, hey, I'm doing a multifamily deal. Do you have someone that's done some of these, ask them. They'll find. So they want your business.
Yeah, and all of the big boys here, I mean, do a good job as long as you are in with the right group and you're in with their commercial group, and and development group. I mean, I'm trying to think who I've had really bad experiences with, and there's been a couple, but it's like probably don't. But for the most part.
I'm curious if you have a preference for one, because it's like I work with three, but it's kind of like whichever one's the seller wants. It's like, oh, I like that guy. But
Yeah.
we're going to do this team for the buyer. Do you have a preference?
I don't. Does anyone else have a preference? Someone that you love?
I mean, I've used First American a lot.
Who is that? First American? Yeah, I have worked with First American. They do a great job.
First American, Meridian Title, and Cottonwood.
Cottonwood, I've always had good luck with as well. Yeah. Yeah.
Any other questions?
Yeah, question for you. So, how likely with cities, it seems like they want to modify like their pre-existing restrictions.
I'm sorry.
So with cities, it seems like a lot of the cities don't like to modify their development agreement. What do you think the best way is to remedy that and say, what have you seen in cities may do that you like that we should keep our eyes out for?
So I would answer that. So the question was if cities don't seem to want to modify development agreements and kind of how do you navigate that? That's where that first meeting becomes really, really important because they're going to say, hey, property XYZ has a DA on it. Have you looked at it? Or the DA that's on there is not going to match, and we usually don't change those. I walk. Right? So don't, and I think that's the other kind of cautionary tale. Like, never go into a deal that you just got to do, right?
So you're just saying personally what you're referring to just like calling the planning department, verifying what it's already zoned as, right? Because they're just going to attach the development agreement that's already kind of their.
Yeah, but you have to ask them, or hopefully you've already looked at it and you know that there's a DA on the project, and you've kind of gone through it and been like, ooh, this is not going to work. Because some of those DAs, as I think you asked the question, they can be super specific as to exactly what the future of that property, what the options are. So I ask them. I've never had any real problems with that. I mean, that's kind of almost, we're going to negotiate the preliminary plat. It's going to have all these conditions, and it just flows right into that development agreement. So I've never really had any bad experiences where the city is just like, no, we're not going to do it.
But if you see it, it definitely needs to be a contingency in your agreement up front.
And they can take the position that they're not going to change it. And if they can't, and you can't do your projects within the four corners of that agreement, you should probably walk.
Well, we've got a project we're doing right now, and it's done. Basically, the city's not approving it because of the pipeline that they put in. It's like on our property, which is outside of our development agreement. So anyway, I'm just curious, like, could we have gotten them to change something? Because they didn't bring that up if they wanted to do it.
Yeah.
Yeah.
And I thought, yeah, we could, only get it to your own thing. In hindsight, I wish I would have said hell no.
Yeah. I think that's one thing. It kind of, since you went there, I used to take the approach, whatever the city the city got. And man, I've backed off on that because I have to say almost every single offsite that I've ever done literally will become the bane of my existence for that project. And it's the cost overruns, it's all this stuff. And you think you're being nice, and guess what? You're probably getting that project approved anyway, with maybe like the exception of, let's say you got to do a lift station or something, something that's significant infrastructure. But that's those little things. I try not to give them anything that's not required by code. I don't give it to them. Yeah, it's not required. It's not required. And I've had that in city council meetings. Well, would you give us a path? No. I don't have to. It's not in the code, and it's not in, rattle off those documents. It's not in any of them. So no, I'm not giving it to you.
Yeah.
So, anyone else?
Is there anything you guys put in your purchase agreements that
before, and now it's like, okay, I gotta have this stuff in the purchase agreement. Like, any anything to talk on that?
I know my purchase agreements. Do you guys have form agreements here?
Yeah.
So
but I don't use
they
them.
probably have state form agreements. Those things are crap. In Idaho, they are not designed for land deals, and they're horrible. Go, like find one. And mine. I have several.
It's too easy to miss things because you know,
Yeah.
the forms are set up to where, well, then this is applicable if you check this, and if you don't check this, and then going through all of the addendums. So I mean, yeah, that's the.
Or they have the
one
paragraph that's just a bunch of lines so you can write stuff in. That's always a bad sign. You use a real document. That's what I tell people. And I've had sellers come to me and be like, no, I really want to use this. I'm like, no, I'm not going to do it.
But I mean, I can't think of anything off the top of my head. I mean, I've had so many bad experiences that over 30, something years that I don't know. Most of it is covered in what I usually start with in basic forms. It depends on how big the deal is and kind of what the structure of the deal is. But if you're doing anything significant and you're doing it in a 3-page agreement, I think you got a problem.
Yeah. My shortest one's 12 pages. Mm-hmm. My longest one's 25.
All right. Okay.
But that ranges from, $50 million multifamily deal to $1 million piece of dirt. Those are two completely different beasts. But I think a purchase and sell agreement should be pretty robust.
Yeah.
And I mean, I'm a lawyer and I hate legaling up stuff, but you got to have it. It's there for you. It's for your protections.
So when you're taking on a client, like what does your role look like? Are you just providing or suggesting contracts, or are you helping with like due diligence stuff, or like what?
It varies.
It varies, and it really is kind of what does the client's bandwidth inside their company have. So that's the difference of
and what did the economics of the deal justify as well.
Yeah, that's a really good point. I mean, it's a difference of a $1 million deal and a $20 million piece of dirt we're buying. Drives that, and it's also the difference of, I've got one client, it's 2 guys that sit in a little office. I've got another client, they have 100 people. They have an acquisitions group. They've got 5 guys doing due diligence. Guess what? They don't need me doing due diligence. Mm-hmm. So it just kind of varies. But I think that's kind of the advantage of our background. We kind of can come at it from a legal perspective, but also from a business perspective, and kind of help you go through A to Z on a project, but also say, hey, look, you asked about the agreements. You might have a seller come back to you and be like, oh, I don't like this. It's my job to say, well, from a legal perspective, I can tell you this, but it's also my job to tell you, yeah, but your risk of exposure is really 1%. As opposed to, well, your risk of exposure is 80%. We should probably go negotiate this. So,
which is sometimes a difference in the perspective I think that Wade and I have, just based on our experience that we spent so many years in-house. I need to get deals done, and I can't. You're right. I mean, I can come up with a laundry list of all of the problems that could come up with this. Well, guess what? If the bottom 10 problems, if something happened with those, trust me, if those came up, trust me, I got bigger problems. Yeah, if the deal went south, because of one of those. And so there's a fine line between doing a good job as your lawyer and advising you and over-lawyering things. And some of that is, through discussion. Some of it is you've just worked with a client long enough and you understand where their risk tolerance is. And then some of it comes down to economics, and that's one difference that Wade and I have with going and just hiring the big law firms, because they generally haven't been on the business side of it. Where Wade and I have had to be in-house. We were just one piece of, okay, this deal has to get done, and I've seen too many times where the lawyers just have a different perspective when they're the outside counsel, because they've got to protect themselves from liability as well.
Yeah, I struggle with that with a lot of law firms. They'll kill deals for you really fast, and you do have to kind of balance that, and they need to understand your business. And I've got some cowboys, dude, they'll do any deal. And I've got some other guys, super conservative. I approach those contracts in two completely different ways.
And that's one reason why we formed, our on-demand general counsel, because we have this general counsel mentality, and part of that is to help our clients and these smaller companies to not only look at things and get some things done that they normally wouldn't have an attorney look at because of cost, but to also then step in and manage the outside counsel who is telling them, oh no, we need to do this and we need to do this, and somebody with our experience can step in and say, no, here's the scope of what I need you to do, outside law counsel. We understand the rest of it. We need to do that. And so that's kind of one reason that we've done what we've done. So,
anything else? Well, thanks for your time.
Appreciate all the questions and your interaction. It's what's going to best serve you. We also have put together that, and I think, there you go. I think that we put together a bunch of pizza for you, so it's free. It's on the house. You guys can. We're going to bring it in and place it right there. Yeah, I think that what I might actually even do is pull on Jeff's arm a little bit more, or grab one of my other different relationships and talk a little bit more on to the city navigation side and development agreement. I've encountered a ton of development agreement from the good and the bad side, having to come in on a consulting level and help them get reoriented and resituated within a development agreement that is way old and no longer meets market, right? Because that can happen too. So I think that I'll probably do some class coming forward that will talk a little bit more about that. And also, one of the things that I despise a ton is, I think that sometimes the cities think they have more authority, and we talk to this, than they really do. And to have a group that really understands the process and how to navigate the conversations with the city, so that the city fulfills on their obligations, but don't over encumber you on what your needs for your group and your team and your money to find success. So I think that we'll position something to be able to talk further on that. I'd love to hear more from their experience as well, is allow you guys to draw from my experience in talking to that. Appreciate you coming. Again, any questions you have, you can come and find us, or you can, just schedule a time and meet with our team and bring any project or question you have around a project. We've seen pretty much about anything. I think that January is a good idea. I think it would be of a blessing to you to come and figure out what Steve's all about in being able to bring a value in how you handle problems and get emotional bandwidth back to be able to handle the complexity of land development. And then if this was of value to you, we want to know that. Even if it wasn't, we want to know that so that we can get better and be better. Does that sound good? Appreciate it. Thank you for coming. We'll go ahead and bring the pizza in.